of the law of guarantees, the popes declared themselves prisoners of the Vatican of the new Italian state. This situation persisted until February of 1929, when the Lateran Pacts created the microstate of Vatican City, and the Holy See recognized Rome as the capital of what was the Kingdom of Italy at the time. The City of London Corporation is the governing body of the City of London, which is home to most of the United Kingdom's financial sector. It is nicknamed the Square Mile. While there is no surviving record of a first charter establishing the corporation as a legal body, it is said to be regarded as incorporation by prescription, or that the law presumed it to be incorporated since it had been regarded as such for so long. The history of the City of London Corporation's first recorded royal charter was said to date back to one granted by William the Conqueror in 1067 AD, with much in its history of one kind or another since that time. The coat of arms of the City of London Corporation was said to have been in use since 1381, and is anciently recorded at the College of Arms. The dragon supporters on each side of it, and the crest at the top, were said to have been added in the early 17th century. The basic similarity with the red crosses on a white background between these three coats of arms is unmistakable. Oh yes, and there's this red cross too. Back to the United States. According to the information that MJ provided me from her research, before the 1871 Organic Act, the states operated on the 10 Bill of Rights and the 10 Commandments. People were tried according to the 1215 Magna Carta and by a jury of their peers. The Magna Carta was a royal charter of rights and freedoms granted by King John in June of 1215 in our historical narrative. It was believed to be a unique and early charter of human rights. She said there were no judges, no district attorneys, no police, and no fines, licenses, or taxes. Individual states were considered sovereign, and revenue for the states was obtained via tariffs. These tariffs were based on trade between states, and a company established outside of the borders of the state was considered foreign, and still is. MJ looked for, and couldn't find, the first name of the corporation that owned the District of Columbia, the City of London, and the Vatican. She said, however, the name then and now can literally be anything provided the terms doing business as or DBA is denoted. Doing business as is a trade name. A trade name is a pseudonym used by companies that do not operate under their registered company name. The term for this type of alternative name is a fictitious business name. MJ said the name of the corporation that owns the District of Columbia, the City of London, and the Vatican is presently called the Corporation Service Company, or CSC, with several DBA names. The individual states were not considered a part of that corporation, yet incorporated cities were typically established by an overseas foreign corporate entity, like for example the founding of New Ulm in Minnesota in 1854 by the German Land Company of Chicago. Overseas corporations scrabbled to incorporate cities in America to create revenue. Taxes, fees, fines, and licenses were money makers. Early on, these were very nominal. It wasn't until the Buck Act of 1940 that states, cities, and counties started bringing in admiralty law, the real money maker and enslavement apparatus for the corporation. The Corporation Service Company, DBA, the United States Corporation Company, was able to gain access to the pocketbooks of the people residing outside of the District of Columbia. MJ provided the information on how this was accomplished. The federal government instituted Social Security in 1935. Subsequently, the Social Security Board created 10 Social Security districts, thus creating federal areas which overlaid the states. Then in 1939, the federal government instituted the Public Salary Tax Act of 1939, a municipal law of the District of Columbia that taxed all federal and state government employees and those who work and live in any federal area. Since the government knew that it could not tax those who live outside of the territorial jurisdiction of the District of Columbia, the Buck Act was passed in 1940 that allowed any department of the federal government to create a federal area for the imposition of the 1939 Public Salary Tax Act, with the overlay for federal areas created by the Social Security Board in 1935 already in place, and the rest of the taxing law was contained in the Internal Revenue Code of 1939. It opened up the entire country to the bar, and each elected official was then considered employees of the Corporation Service Company. States were annexed one by one. In Minnesota, the state became the state of Minnesota in 1966. She said that when the states create a program, they also create shell companies. Usually the owner is the registered agent of the company. She said there are over 5,000 companies reported at 2345 Rice Street in Roseville, which is north of St. Paul, the state capital of Minnesota. This address is a 1970s office building where the Corporation Service Company has a large office suite. She said the listings exploded in March of 2021, that they started listing about 200 a month. She found out that when she searched for these companies, they either didn't have a website or they have a false front website. She said by the end of the 1970s, all states had been annexed by the Corporation Service Company. The Buck Act made it legal to levy taxes and federal law on the people. Annexation of individual states made it possible for the state politicians to also get in on the money-making action. State universities and public schools also became larger money-making ventures. The Corporation Service Company has been with us in all aspects of our lives. She said this used to be visible on Dun and Bradstreet, but they've removed access to the information. She provided an example of an old screenshot of Dun & Bradstreet data and said one thing to keep in mind is that .gov is also DBA CSC, or the Corporation Service Company. Does the natural government that existed prior to the company still exist? MJ indicated that yes, the natural government that existed prior to the company still exists today and is paid for by the U.S. Treasury and not the Corporation Service Company. She explained it as follows. Sheriffs, U.S. Marshals, and the military are all part of the natural government. She said that prior to the Organic Act of 1871, congressmen and senators didn't get rich holding any of these elected seats. Nearly all of them kept their day jobs as farmers, ranchers, merchants, etc. They had to live and work among their constituents and answer to them in person, unlike today. She repeated that the United States is a constitutional federal republic and not a democracy as it is so often characterized, and that our law is common law or natural law and is written in the plain English of the 1828 Webster's Dictionary. She said that the process is articulated in the First Amendment. She explained the following. The first part of the First Amendment translates to Congress being forbidden to make any laws that have to do with anything in regard to free speech or the right to speak or limiting speech. It is saying that government cannot make any laws in reference to speech at all. The press does not mean just journalists. Freedom of speech and of the press applies to everyone. She said it's the second part of the First Amendment that has really been convoluted concerning the right of the people to peaceably assemble. Assemble means to convene or congregate. She said it's not about religion, but it can be. She explained that the rest of the First Amendment states, and to petition the government for redress of grievances, and that in this case, with the reference to assemble, it means to convene government to make them repair their wrongdoings as written out. Or, in other words, the right to assemble means the right to convene their government and to read the written transgressions and to fix it. She said petition does not mean just a bunch of signatures. It can have a bunch of signatures on it, but it's really a handwritten document that outlines the grievances to be fixed. She said this is also part of the government's process in their own manual, Mason's Manual of Legislative Procedure. Mason's Manual has been adopted by the federal government and by most state houses as the official parliamentary authority, covering for legislatures things like motions, vote requirements, and rules of order. It was first published in 1935 by Paul Mason, a scholar who worked for the California State Senate. She said there are a few states that have adopted Jefferson's Manual, which refers back to the plain language of the Bill of Rights. She said that everything that we're talking about here is under common law, and that admiralty law can play musical chairs with the language and words, but common law cannot. And no courts shall come between the people and their government. She said that state